What's going on, YouTube? Listen up, young elder gang. This is Malik Carter at you with another banger. Please make sure you like, subscribe, and share this video, fam. I hope this video get at least 100,000 likes in this video. You will find history definitions, scripture, information, and best of all, what we Americans have been deprived of from the beginning. The truth, keep in mind, this content used in this video is intended for entertainment, educational, and informational purposes only, and does not constitute legal advice or create an attorney-client relationship. You should not act upon any information on this site without seeking the advice of a competent attorney for your specific situation. We will give you the total truth as we best understand it today. Be sure to hit that like button. Young Elder Gang, hit that subscribe button if you're new to the channel. Hit that bell and don't forget to check back with us every day for new content. Now, Young Elder and Chief Rod Hayes gave me some files to look over, and here's what I come up with. Courts look grand, robes, gavels, columns. On TV, they serve justice with flair. But that image is mostly an illusion. Most places you go aren't true courts. They're administrative tribunals, more like a manager's office than halls of justice. The illusion is about to be shattered. This is no ordinary courtroom. Today, the Moors, the original sovereigns of this land, bring charges against the United States Corporation. They allege a foundational fraud. The American legal system was built on a poisoned root, hijacked by interests seeking empire through our dispossession. The Constitution was not misinterpreted. It was commandeered, replaced by a corporate structure for control and extraction. We will show a deliberate conspiracy. The Judiciary Act of 1789, the Residence Act, the Naturalization Act, and the Patent and Copyright Acts were all tools of theft and exclusion. These acts are not isolated. They form a pattern of systemic fraud against the Moors' sovereignty. This evidence will prove these laws are void from inception, fruit of the poisonous tree. The original act of deceit corrupted every law, statute, and ruling against the Moors. My clients. The Moors demand rescission, the cancellation of these fraudulent contracts, and restoration of what was unlawfully taken. The ambiguity in American law was designed to confuse and entrap the sovereign people. My clients do not seek damages. They demand the return of their sovereignty. The United States Corporation has masqueraded as a legitimate government. Today, we pull back the curtain on its history of deception and theft. This tribunal is not about grievances, it's about exposing a grand fraud. My clients, the Moors, stand as sovereigns, not plaintiffs. The time for truth and restoration is now. A silent war for your mind has been waged, a battle to control perception and reality. The Moorish people and all on this continent have been trapped in an invisible prison. We expose the architects, a covert corporate takeover engineered by anonymous Freemasons and their agents within United States, Incut. Under George Washington to Lincoln, the Constitution and its branches were hijacked. A corporate entity seized the states, banking and money creation. Civil war, bankruptcy, and confiscation of wealth followed, justifying perpetual emergency and enslavement under the color of law. In 1938, the Supreme Court's rulings were split. Common law was barred, replaced by the Uniform Commercial Code and Admiralty Courts. People became commercial entities, vessels in a sea of contracts. Most remain unaware, signing themselves into commercial slavery with every government document. The system we revere is the true enemy, a corporate fiction masquerading as government. The illusion of freedom keeps us shackled. Sovereignty was transferred to the corporation. European feudal principles were quietly reinstated. The corporate state became sovereign. The people, its subjects. The state is never on equal footing with the people in court. This is not government by the people, it is a corporation. The Moors are here to prove it. We demand its dissolution. The fruit of the poisonous tree is simple. If the root is poisoned, all that grows from it is tainted. In law, if the initial act is illegal, Everything derived from it is void. This doctrine prevents the state from profiting from its own misconduct. A government of laws cannot stand on lawlessness. When the foundation is fraud, every law and ruling that follows is an extension of that crime. The USA corporation's legal system began with a deliberate breach of the constitutional compact. This was no accident, it was a calculated power grab. From this poisoned root grew a forest of fraudulent legislation, every law dispossessing the Moors, every statute stripping identity, every unjust ruling is fruit from this tree. All are void and ripe for rescission. The initial illegality infects the entire chain of American law. We are not debating individual laws. We are exposing the contaminated source. The entire system must be condemned. This is a grand fraud against the Moors and all people here. The time has come to uproot the poisonous tree. We must plant the seeds of true justice. In 1789, the Judiciary Act injected poison into the American legal system. Section 13 granted the Supreme Court powers beyond the Constitution, an unauthorized expansion. Congress presumed it could alter the judiciary's authority, a monumental overreach. This act allowed the Supreme Court to become a political power, not an impartial arbiter. It introduced deliberate ambiguity, laying the groundwork for centralized control. For the Moors, the consequences were immediate. A federal court system designed for land theft and dispossession. The act recognized only white title, reducing our ownership to a right of occupancy, easily extinguished. It ignored our sovereignty, casting us as obstacles or wards of the state. This legal fiction justified seizure of our lands without consent. Federal courts were imposed on our lands, subjecting us to hostile foreign jurisdiction. The Judiciary Act was the original sin, invalidating federal authority over the Moors from the start. It was the poisonous tree. Its first fruits were our disenfranchisement and dispossession. The Judiciary Act was the poison. Marbury v. Madison in 1803 was its activation. This case, celebrated as the birth of judicial review, was actually a judicial coup. A trivial dispute became the pretext for the Supreme Court to seize ultimate authority. Chief Justice Marshall, with a glaring conflict of interest, declared Section 13 unconstitutional, admitting the tree was poisoned. Yet he used this to claim the court's power to strike down any law, a power never granted by the Constitution. Judicial review was born from a tainted act. The court made itself the sole interpreter of the Constitution, unchecked and unbalanced. This was not a check on power, but its consolidation. The promise of three co-equal branches was shattered. The judiciary became supreme. Every subsequent decision was suspect, enabling dispossession of the Moors and protection of corporate interests. The Marbury decision was not a defense, but a subversion of the Constitution. It cemented a system where the court validated theft and fraud. The roots of American law were poisoned forever. The judicial coup must be recognized for what it is, the ultimate betrayal of justice. Keller v. Potomac Electric, 1923, where the Supreme Court decided that setting public utility rates in D.C. was an administrative act, not a judicial one. The D.C. courts weren't true constitutional courts. They were legislative courts created by Congress to manage, not judge. Their authority was administrative, not judicial, just extensions of Congress, not independent courts. Keller revealed the illusion of independent courts, and it only got worse. Think Keller was a one-off? Enter Federal Radio Commission v. General Electric, 1929. GE wanted a radio license renewal. The Federal Radio Commission said no. GE appealed, and the D.C. courts sided with them. The Supreme Court refused to hear the case on its merits, declaring the lower court's decision wasn't judicial, it was administrative, meaning give me some money, which you have none, by the way, since HJR 192. The lower court was labeled a superior and revising administrative agent. A supposed court of justice was officially just an administrative agent. This cemented the precedent. Congress could create courts that were judicial in name only. These courts weren't part of the constitutional judicial branch. They were tools for enforcing federal regulations. Their decisions weren't acts of justice, but acts of administration. The separation of powers was fundamentally betrayed. When a judge rules on a government agency case, are they an impartial arbiter or just another administrator? The FRC case suggests the latter. The gavel had become a rubber stamp. How did we get from the founder's vision to this bureaucratic maze? It started with the Judiciary Act of 1789, which set up the federal court system. The Constitution created Article 3 courts, independent, with life tenure and protected salaries. But Congress also created Article 1 courts, legislative or administrative courts, to handle specific issues. This created a two-tiered system, constitutional courts and administrative courts. Over time, especially in the 20th century, administrative courts grew to handle most cases. Administrative law began to overshadow constitutional law. The result, a bait and switch. We were promised independent courts, but got a system dominated by administrative bodies. These bodies aren't bound by strict due process. They operate under a presumption of administrative correctness. The government agency is assumed right until proven otherwise. The framework for a parallel legal system was laid in 1789. It looks like a court system, but functions like a bureaucracy, and we've been living in it ever since. Remember learning about the three branches of government: legislative, executive, judicial, a neat triangle of checks and balances set up by the Masons. In reality, the rise of the administrative state created a shadowy fourth branch, the vast network of agencies like the IRS, EPA, and SEC. These agencies have their own courts, administrative law courts. In these courts, the agency is prosecutor, judge, and jury. An agency employee, not an independent judge, presides. Separation of powers, gone. Dispute with the IRS, you go to tax court, an administrative body, not a constitutional court. The judge's job is to administer tax law, not debate its constitutionality. The system is designed for compliance, not justice. Supreme Court cases like Keller and FRC confirm these are administrative functions, not judicial ones. The branches of government merge. The agency writes, enforces, and judges its own rules. Judicial review is often limited to checking if the agency followed its own procedures. The court isn't asking, is this constitutional? Just, did the paperwork check out? Do the contracts look good? If courts are administrative, what law are they enforcing? Contract law. From social security numbers to driver's licenses, you're entering contracts with government and corporate entities. You agree to follow their rules in exchange for privileges. These aren't constitutional rights, they're contractual obligations. In court, for a traffic ticket, it's not about your right to travel. It's about whether you broke the contract of your driver's license. The court's job is to enforce the terms of that contract. That's why courts focus on procedure and statutes, not philosophical justice. The judge is an administrator. Did you follow the rules you agreed to? Arguing broad constitutional principles in traffic court gets you nowhere. The judge's jurisdiction is limited to enforcing the statute. By participating in society, we've unknowingly waived many constitutional protections for administrative contracts. The government is a corporation offering services with terms and conditions. Courts are its enforcement arm, ensuring everyone keeps their side of the bargain. They're not courts of justice, they're courts of commercial administration. So here we are, administrative tribunals dressed as courts, managing a system of contracts we never really chose. The independent judicial branch has been sidelined by bureaucracy. What can we do? First, understand the game. Knowledge is power. When you see courts as administrative bodies enforcing contracts, your perspective shifts. Don't ignore the rules. They're enforced ruthlessly. But learn the real rules: administrative procedure and contract law, not constitutional law. This reality has profound consequences. Without genuine judicial review, there's no brake on government power. Rights become privileges, granted or revoked at the state's discretion. The Constitution becomes a relic, admired but not followed. Reclaiming our judicial system requires public awareness and demanding true independent courts. It's not easy. Undoing a century of precedent and bureaucracy is a massive task, but the alternative is to keep living in the illusion, thinking we're free citizens when we're just subjects in a corporate state. And that's the forbidden truth. The Judiciary Act planted the poisonous root. Marbury versus Madison cultivated its growth. The Residence Act of 1790 was a declaration of war. It was waged with surveyors' lines and fraudulent land titles. The target was the ancestral lands of the Moors. This was not about building a nation. It was about erasing ours. Its seizure symbolized the new order. Washington, D.C. was built on stolen Moorish land. It was the physical manifestation of a legal coup. For the Moors, it was the ultimate betrayal. The Residence Act of 1790 set the blueprint for continental theft. Insiders rushed to buy up Moorish land, using legal tricks and threats to dispossess the rightful owners. This was state-sponsored gangsterism, not free-market capitalism. The act turned sovereign people into trespassers, their ancient claims dismissed as invalid. Washington, D.C. became a tombstone for Moorish sovereignty, a city built on dispossession, its marble columns a testament to foundational theft. The Residence Act was the first step in stealing not just our land, but our identity as sovereign people. The creation of federal territory enabled a vast system of control: addresses, post offices, and census tracts. These are the invisible bars of a prison, reclassifying sovereigns as residents. The address is not just a location, it is a legal status, binding you to the federal grid. This is the prison without bars, operating through your unknowing consent. The Residence Act turned a nation of Moors into a population of U.S. residents. After seizing our land, the United States Corporation deployed new legal weapons to steal our intellectual spirit. The Patent Act of 1790, presented as noble, was a tool for legalized theft, stripping the Moors of their inventions. It ensured our genius became property of the corporate state, not our own. The system was rigged, making it easy for the corporation to steal our future and control innovation. If the Patent Act was designed to steal our future, the Copyright Act of 1790 was its sinister twin, crafted to steal our past. It gave the state power to decide who owned history, allowing agents to seize our sacred books and erase our truth. Books were confiscated, rewritten, or destroyed. Our kings turned to savages, our science to superstition. The Copyright Act was the legal weapon used to erase our story and lock us in a historical prison. The Patent and Copyright Acts of 1790 were not just laws, they were weapons, severing the Moors from both past and future. The Copyright Act locked us out of our history. The Patent Act locked us out of our future. This strategy trapped us in dependency, erasing our identity and making us buy back our own genius. To reclaim our story, we must expose and reject these acts, steps toward unlocking our true heritage. The Naturalization Act of 1790 was a weapon of racial purity, codifying exclusion and erasing the Moorish people from the new American body politic. By limiting citizenship to any free white person, it drew a color line in law, creating a caste system and denying us rights. We became foreigners in our own land, stripped of legal personhood, ghosts within the system. This act was not about liberty, but about exclusion. It is void ab initio. The Naturalization Act was not an isolated piece of legislation. It was the keystone in a larger arch of laws passed in the 1790s, all designed to entangle and dispossess the Moors. The key legislation of this era, viewed together, reveals a coordinated strategy of subjugation. While the Judiciary Act created the biased courts and the Residence Act seized the land, other laws solidified the economic and social control. These acts were the practical application of the power that had been unconstitutionally seized. They created a complex web of regulations that made it impossible for the Moorish people to function as a sovereign or even a free people. Every new law was another thread in the net, another bar on the invisible prison. Consider the other foundational acts passed in 1790. Each one, while seemingly benign, carried a hidden barb for the Moors. These laws worked in concert, creating a system where participation meant submission and non-participation meant destitution. They established federal authority over commerce, over debt, and over every aspect of civil life, all while defining the Moors as being outside the protection of that system, yet subject to its punishments. This legislative flurry was a response to the power vacuum the judiciary had created. Having established its supremacy, the federal machine began churning out the tools of control, each one sharpening the blade of dispossession and reinforcing the racial hierarchy established by the Naturalization Act. This web of laws was designed to create confusion and despair. For the Moors, navigating this new legal landscape was impossible. Treaties were ignored, ancestral laws were invalidated, and our leaders were treated as common criminals. The barrage of legislation from the First Congress was a form of shock and awe, a legal blitzkrieg intended to overwhelm and paralyze us. It was a clear signal that the new corporate government would not negotiate, it would not accommodate, and it would not recognize our sovereignty. It would only legislate us out of existence, burying us under a mountain of statutes, acts, and codes that were impossible to comply with and fatal to ignore. This was law as a weapon of conquest. Ultimately, all of these key legislative acts are void. They all stem from the same poisoned source, a Congress and a judiciary acting beyond their constitutional authority. They are the fraudulent instruments of a fraudulent entity. From the Bill of Rights, which was crafted to appease anti-federalist settlers but never intended to apply to the indigenous Moors, to the financial plans that consolidated the nation's wealth in the hands of a few, every act was a step further down the path of corporate tyranny. The entire legal framework of the 1790s is a testament to the original fraud. It is an elaborate architecture of control built on a foundation of sand, and we are here to witness its collapse. The poison of foundational fraud seeped into the American legal system, creating an invisible prison we live in today. Courts have become engines of institutionalized injustice, where justice is a commodity for sale. The chains are contractual and psychological, but no less real. Corporations fund lavish perks for judges, ensuring a pro-corporate bias in the judiciary. This is the grim reality of the prison without bars, a system we, the Moors, are here to expose and dismantle. We have presented our case before this tribunal of history. The poisoned roots of the American legal system trace back to the unconstitutional power grab of the Judiciary Act of 1789. We demand the rescission of acts that stole our land and identity. The sovereignty of the Moorish people must be recognized and restored. This is the beginning of a restoration of justice and true history.